I'm Jameel Jaffer. I'm the director of the ACLU's National Security Project. This week I'll be in court representing Pan American Center and a number of other plaintiffs in a challenge to the FISA Amendments Act, which is a statute that Congress enacted last year. The FISA Amendments Act allows the government to engage in the dragnet acquisition of Americans' international communications, both their emails and their telephone calls. It allows the government to acquire those communications without making any individualized showing to a judge, without, for example, showing probable cause to a judge, without describing the phone lines or the email accounts to be monitored, without describing the communications to be intercepted. The law essentially gives the government unfettered access to Americans' international communications. And we think that the law violates both the First Amendment and the Fourth Amendment. The First Amendment, which protects, of course, the freedom of speech and freedom of association, and the Fourth Amendment, which protects against unreasonable searches and seizures. The plaintiffs in the case include, of course, Pan American Center, also a number of lawyers' organizations, human rights organizations, labor organizations, and all of them share a concern that this law allows the government access to their international communications. All of the organizations engage in sensitive and sometimes privileged communications with people who live outside the country, and this law compromises their ability to do their job, compromises their ability to gather information from sources, in some cases requires them to take costly and burdensome and time-consuming trips to gather information in person that they might otherwise have been able to gather over email or by telephone. Overall, the law undermines their ability to engage in completely legitimate work, not just legitimate work, but work that is essential to any democracy. One of the critical questions in the case has to do with standing, our right to challenge the law. The government is arguing that we don't have the right to challenge the law because we can't show with certainty that our communications have actually been intercepted under the law. But the problem with that argument is that nobody will ever be able to show that their communications were intercepted under this law. The government surveillance takes place completely in secret. Nobody is notified that their communications were wiretapped. They certainly aren't notified while the wiretap is ongoing, and they're not notified even after the wiretap has been completed. And so if people like us can't challenge the law, then nobody will be able to challenge the law. I think that most people have heard about the Bush administration's warrantless wiretapping program. This is something that President Bush inaugurated in 2001. It was exposed by the New York Times in 2005, but rather than punish the people or hold accountable the people who had authorized the program, which violated not just the Constitution but a federal statute, what Congress did was create a new statute, amend the statute to allow for the warrantless wiretapping to take place consistent with U.S. statutory law. The statute we're challenging now is the statute that essentially codified the Bush administration's warrantless wiretapping program. It allows the government to acquire huge numbers of Americans' international communications, and to do so without showing to a court that those people are engaged in anything criminal or anything wrong. It's a law that it really is the most far-reaching surveillance statute ever enacted by the U.S. Congress.